ठिकाणी असं नाही करायचं. एवढे मोठ्या मिटिंगला महत्वाचे माझे दाखवते थोडंच. हा मॅडम नमस्कार.
डोले सर सुरू करा. हॅलो सर. काय नाही
Good morning and welcome to one and all. Today, Rayat Shikshan Sanstha's Sadguru Gadage Maharaj College, Karad, Department of Physics, in collaboration with Internal Quality Assurance Cell and Institute's Innovation Council, organizes one-day e-workshop on intellectual property rights awareness. We'll start today's workshop with our Rayat ji.
रयते मधुनी नव्या युगाचा माणूस आता घडतो आहे. वटवृक्षाच्या विशालतेचा मोहन भाला पडतो आहे. रयते मधुनी नव्या युगाचा माणूस आता घडतो आहे. वटवृक्षाच्या विशालतेचा मोहन भाला पडतो आहे. रयते मधुनी नव्या युगाचा. कर्मवीरांचे ज्ञानपीठ हे शक्तिपीठ ही ठरते आहे. शाहू फुल्यांचे समानतेचे तत्वमानसी मूर्ते आहे. धर्म जातीच्या पार गांधींचे मूल्य मानवी जपतो आहे. रयते मधुनी नव्या युगाचा माणूस आता घडतो आहे. वटवृक्षाच्या विशालतेचा मोहन भाला पडतो आहे. रयते मधुनी नव्या युगाचा. ही लेणी मोडून लक्ष्मी वहिनी झाली आई. कमवा आणि शिका मंत्र हा तरुणाईला प्रेरक होई. स्वावलंबी वृत्ती ठेवून ज्ञान साधना करतो आहे. रयते मधुनी नव्या युगाचा माणूस आता घडतो आहे. वटवृक्षाच्या विशालतेचा मोहन भाला पडतो आहे. रयते मधुनी नव्या युगाचा. दलितांसाठी अण्णा तुमची झिजली चंदन काया. अनाथ जीवा सदा लाभली मातृ हृदयी तुमची माया शून्यामधल्या नवसृष्टीचा निर्मिक तोही ठरतो आहे रयते मधुनी नव्या युगाचा माणूस आता घडतो आहे वटवृक्षाच्या विशालतेचा मोहन भाला पडतो आहे रयते मधुनी नव्या युगाचा जीवनातला तिमिर जावा प्रबोधनाची पहाट व्हावी इथे लाभले पंखले उनी उंच भरारी नभात घ्यावी प्रतिभाशाली बहुजनांचा वेलू गगनी चढतो आहे रयते मधुनी नव्या युगाचा माणूस आता घडतो आहे वटवृक्षाच्या विशालतेचा मोहन भाला पडतो आहे रयते मधुनी नव्या युगाचा
Thank you very much, one and all. Without wasting too much time, I request Dr. Abhijit, President of CIII, to introduce for this workshop. Over to Dr. Abhijit.
Thank you, Dhule sir. Good morning, everybody. First of all, I really appreciate Department of Physics and Thorat sir for organizing such an wonderful workshop on the hot topic of IPR, and thank you for giving me an opportunity to talk in front of you. For a few minutes, I will talk on why IPR is necessary. Initially, research of higher educational institutes were graded on basis of how many research papers you people produce, but gradually it was found that there is no direct use of these research papers or research produced in research papers for human being. So these grading institutes started to grade these higher educational institutes on basis of how many IPRs or how many patents you people produced. Now, what is the research, what is innovation, invention, and how it can be converted into IPR? For that, I will give you a simple example of FASTag. The technology used in FASTag was discovered in 1983 by Charles Walton. That is radio frequency identification technology. At that time, that man took the patent. Now, this is the invention. He invented the technology, radio frequency identification technology, but it was converted into an innovation in the form of FASTag. In last decade, we are using this invention as an innovation that is useful to human being in the form of FASTag. So we have to do the research. We have to convert this research into something useful to human being, which is called as innovation. And not only just convert it into innovation, we have to convert these innovations into IPRs. Further to that, we have to commercialize these IPRs. That means we have to gain something that we have produced, that we have invented, and that we have converted into innovations. You people, you physics people, you work in supercapacitors, you work in nanomaterials, you work in batteries. What we can do, just do not produce a material and publish it in research paper. Convert these materials into anodes, cathodes, or batteries or electrolytes. Construct a battery, design a battery, take patent of this battery, and let's work on commercialization of this design or commercialization of this IPR. This is the main motto. Now, how this can be done? How these inventions can be converted into innovations? How they can be brought up into IPRs? How commercialization of IPRs can be done? For that, we Center of III, that is Center of Invention, Innovation and Incubation, we can help you to convert your invention into innovation. We can incubate your ideas, bring your ideas to us. We will convert these ideas into innovations. We will help you in taking IPR of this invention or innovation or your idea by converting it into patent or trademark or copyright. Now, in this contemporary research world, writing an IPR or writing a patent is very meticulous task. It's not easy to convert your innovation directly into a patent draft. For that, we required a consultant, we required some guests, we required some experts from this IPR to help us, to guide us in how to write this patent, how to bring it into a proper IPR manner. And for that, we have organized today's workshop so that we can know something about IPR, how patent can be written, how IPR can be taken. And I hope in future, our guest, Dhumane sir, Kadam madam, Shalaka madam, they will help us in future for obtaining these IPRs or in case of IPR. So on behalf of Rayat Shikshan Sanstha Sadguru Gadage Maharaj College, Karad, I welcome you all, and with permission of today's president, I will stop here. Thank you all.
Thank you very much, Mohit sir, for your wonderful introductory part. Now I request Professor Dr. J.B.Thorat sir to welcome. Over to Dr. J.B.Thorat sir.
Thank you, Dolly sir. Good morning, everyone. Today we are gathered for one-day e-workshop on intellectual property right awareness organized by Department of Physics in collaboration with Internal Quality Assurance Cell and Institute Innovation Council. First of all, I warm welcome to chief guest of this inaugural function, Honorable Dr. W.M.Dhumane sir, Chair Professor, Maharashtra National Law University, Mumbai. I also cordially welcome the President of this workshop, our dynamic, enthusiastic, visionary, respected Principal, Dr. Mohan Rajmane Saheb. I also welcome our esteemed, excellent, efficient Vice Principal, Professor S.A. Patil sir. Dynamic IQAC Coordinator, Dr. J.B. Kalyanshetti sir. Dr. Abhijit Mudik, President of Institute Innovation Council of S.G.M College, Karad. I also warm welcome to all resource persons, delegates, participants, and faculty members. Before introduce the chief guest, I would like to introduce about our college and department in brief. Our Sadguru Gadage Maharaj College is established in 1954. It is affiliated to Shivaji University, Kolhapur, Maharashtra. It is accredited A+ grade with CGPA 3.63 by NAC. It is a NAC designated mentor college, as well as it is ISO 9001:2015 certified and RUSA beneficiary college. From academic year 2019-20, it is an autonomous college with multidisciplinary courses like UG, PG, and professional courses, and near about 15,000 students learning in this institute. The Department of Physics is a part of this college, which is established in 1965 with special ambition to pursue high-level teaching methodology to deliver a fundamental physics terminology in better way. Gradually, the department has flourished further year by year. The department offers UG and PG course, as well as to develop the research and academic skill techniques among the students. It also provides skill development and short-term courses to the students. The Department of Physics has started MSc Physics program since 2019 so as to develop an advanced center of research in solid-state physics. The department has glorious tradition of eminent and scholar teachers of physics. The faculty has published near about 2,000 research papers in international journals and conferences. The faculty members are always engaged in research. The vision of department is to develop it as an academic excellence in solid state materials and nanotechnology. We are trying to achieve overall development of the students to meet the international standards and to use knowledge of physics for academic and industrial development. The department will take up joint research projects in the field of nanomaterials and thin films so as to fulfill the requirements of the society. Now, I would like to introduce our chief guest, Dr. W.M.Dhumane sir. Dhumane sir has completed his MSc in chemistry and PhD in chemistry from Nagpur University. He has also completed LLB from Mumbai University. He is joined Indian Patent Office in August 2000 as a Deputy Controller of Patents and Design, Ministry of Commerce and Industry, Government of India, and retired as a Senior Joint Controller of Patents and Designs, the highest post in Patent Office on 31st May 2010. He was appointed by the Government of India as a consultant in IPR on 1st June 2010 in Intellectual Property Right Office and worked as a consultant till 9th June 2020. Prior to joining the Patent Office, he was associated with Mineral Exploration Corporation Limited, Nagpur, Government of India Enterprise, and was in charge of its physical laboratory. He was associated with Rajiv Gandhi National Institute Intellectual Property Management, Nagpur, since its establishment in 2011 as coordinator and faculty for training programs for public and official of Patent Office. During association with Indian Intellectual Property Office from 2000 onwards, he has functioned as a statutory authority as Controller of Patent and Designs, was closely involved in IP administration, national and international patent matters, reviewed Patents Act, Design Act and rules, implemented re-engineering of patent procedures, and also functioned as resource person in several IP awareness and training programs in country. He represented Government of India in several international IPR related meetings and seminars held in India and abroad, including World Intellectual Property Organization, Switzerland, France, South Korea, Germany, Singapore, China, and Sri Lanka. At present, he is functioning as IPR Chair Professor in Maharashtra National Law University, Mumbai, from 10th June 2020 under S.G.M for Pedagogy and Research in IPRs for Holistic Education and Academic, launched by Department for Promotion of Industry and Internal Trade, Government of India, and thus encouraging study education and research IPRs as well as promotion of IPRs in the industry and country. I hope that this workshop will definitely be fruitful to develop the enthusiasm of all participants for inventions. Finally, I express my sincere gratitude against our principal, Dr. Mohan Rajmane Saheb, for gave us opportunity to organize this workshop. Thank you. Thank you very much.
Thank you, Thorat sir, for this brief and energetic welcome. Now I request our dynamic principal, Dr. M.M. Rajmane Saheb, for his presidential remark. Over to Dr. Rajmane Saheb.
Good morning, one and all. The chief guest of the inaugural function of this workshop, the chair professor, Maharashtra National Law University, Mumbai, Honorable Dr.W.M.Dhumane sir, Vice Principal of this college, Professor S.A. Patil sir, IQAC Coordinator, Dr. Kalyanshetti sir, President of CIII, Dr. Abhijit Mulik sir, Head Department of Physics, Dr. J.B.Thorat sir, all the faculty members of the Department of Physics, and dear delegates. It gives me a great pleasure to meet you virtually at this inaugural function of one-day e-workshop on IPR awareness for UG as well as PG students and faculty members. This workshop, which is organized by Department of Physics in collaboration with IQAC College and Institute's Innovation Council of Sadguru Gadage Maharaj College. First of all, I congratulate the Department of Physics, IQAC, and Institute's Innovation Council for organizing such important workshop. In introduction, Dr. Abhijit Mulik has already explained in beautiful manner why college has taken the efforts in organization of such workshop. Friends, this workshop aims to provide guidance by resourceful experts across the Maharashtra regarding IPR. Today's speakers are very high quality speakers invited for this workshop. We know that the primary objective of all intellectual property rights to encourage invention by promoting their protection and utilization so as to contribute to industrial development of nation. This workshop will be useful for all participants, for students, faculty members, and all others regarding the patent filing, trademarking, copyright, industrial design, etc. We all know that the patents are having territorial rights, which means that an invention is already protected in the countries or regions where patent protection has been obtained. Trademark is also as a unique sign as well as indicator used by an individual, business organization, and other legal entity to identify that the products and services are offered to the consumer, which the trademark appears. Invention refers to the technical solution to a technical problem. It may be an innovative idea or maybe in the form of working model or prototype. Innovation refers to the translation of invention into marketable product or marketable process. Each and every invention are important in aspect of our country. That's why our country have provision to protect the each and every valuable invention, innovation. For this, we all need to know the process of patent filing, the process of trademark registration, copyright, and others. This workshop will help you regarding the same. I hope the today's expert guidance through this workshop will definitely be useful for all participants. I wish you all a happy listening time. Thank you. Thank you very much.
Thank you, respected principal, sir, for your presidential remark and for gracing this inaugural ceremony of one-day e-workshop on intellectual property right awareness. Now I request Dr. S.H. Pisal Madam for the vote of thanks for this inaugural ceremony. Over to Dr. S.H. Pisal Madam. या की इथे इकडे इकडे.
Good afternoon, one and all. Dignitaries on virtual dais, my colleagues and delegates, I am Dr. Sunanda Pisar, here to express vote of thanks. First of all, I would like to thank Honorable Principal Dr. Mohan Rajmane Saheb for highlighting the theme of workshop and inauguration of IPR workshop function. Sir, we appreciate having this IPR area clarified and highlighting the Rayat Shikshan Sanstha and S.G.M College too. I express my sincere thanks to Vice Principal Honorable S.A. Patil sir, Vice Principal Honorable Nalaude sir, Suryavanshi sir, Mrs. Kamre ma'am, and IQAC Coordinator Dr. Kalyanshetti sir for their valuable guidance and presence. I am also thankful to Professor Dr. J.B.Thorat, Head of Physics Department, for constant support and inspiration. Our thanks goes to a dynamic personality, Dr. Abhijit Mulik, President of CIII Center, for significant work regarding the innovation. I am thankful my colleague, Dr. Dhole sir, Dr. Harari sir, and all other members of Physics Department who take special efforts to choose this important topic and for workshops based organization. Lastly, I hope everyone will be highly benefited by speech of resource person Honorable V.M. Dhumane sir, Honorable Pallavi Kadam ma'am, and Shalaka Tole ma'am, because I have a very good previous experience regarding this workshop. Finally, on behalf of S.G.M College, I am thankful to all who directly and indirectly support to make this workshop very successful. Thank you very much. Now, this inaugural ceremony is over and we will move to next session.
Thank you one and all for attending this inaugural ceremony for one-day e-workshop. Now I request Honorable Dr.W.M.Dhumane sir for his expert lecture. Over to Dr. W.M.Dhumane sir.
Sir, please unmute yourself. Sir, please unmute yourself. Sir, we can't hear you. Dhumane sir, we can't hear you. Please unmute yourself. Okay. Just give us 1 minute. I will do.
Yeah. Thank you very much.
Okay, sir. Okay, thank you.
And okay, I'm trying to share also simultaneously. And sharing is disabled here. Please enable the sharing also.
Yes, sir. Yes, sir. Please give us 1 minute. And sir, there is echo.
Sharing I'm not able to screen the sharing.
You can
Yeah.
you can share now. You can share now, sir.
Yes, please.
Sir, there is echo with your voice. Might be you have logged from two other devices. So please, can you log out with one device so that there will be no echo with your voice?
So, 1 second. Is it visible?
Yes, sir. Your screen is visible.
Is it visible?
Yes, yes, your screen is visible, sir. But your presentation is not visible, and there is echo with your voice, sir. So might be you have logged with login with two devices.
Yes, now. Hello, can you hear me? Can you hear me?
Yes, sir. Yes, sir. We can hear you, but there is echo with your voice.
Echo is coming out. There is echo is coming out from the system. Can you stop the echo, please? Hello, madam. नाही तर नाही echo येतोय. Hello, can you hear me?
Yes, sir. We can hear you, but there is problem with your voice. We are hearing the echo.
How is it clear?
Now it is clear. Now it is clear.
Echo is coming out. I don't know why. Some sound distortion is coming out. Can you check that? So echo, yeah. Now is it clear?
Yes, sir. Yes, sir. Now it is clear, sir.
Yeah. Thank you very much. Thanks for the principal sir, vice principal sir, and other management of the institute. And then I'm fortunate to be here with you and being associated with the names of great saints. Gadage Maharaj from Vidarbha, from where I come, and Sadguru Patil, in whose name Shikshan Sanstha is there. Both these saints have done a lot for the upliftment of the people coming from the root, and their education institutes like this symbolizes their work. This is my second instance to be in the Shikshan Sanstha. I was in Pune.
Sir, sorry to interrupt you. Sir, sorry to interrupt you, but still there is echo, sir. We can't hear you clearly. Please use headphone or otherwise log out and then log in.
नाही तर एकच डिव्हाइसला केलं मी. काय झालंय? हो ते त्यांचा सूर्योदयपासूनच एको येतो, माहित नाही काय फुल सिस्टम त्यांच्या सिस्टमचा फॉल्ट आहे. आता थांबलाय. हॅलो, साऊंड इज क्लिअर. सम डिस्टर्बन्स साऊंड इज कमिंग. Hello. It is clear now?
Yes, sir. Yes, sir.
Okay.
It is clear now.
Thank you. Okay,
sir. Okay.
So, as I said, the echo is coming. The problem is not solved. Why is the echo? Yes, now? Some echo
Yes, sir. Yes, yes. It is clear now.
is coming. Echo. Why?
Sir, might be you have logged in from another device which is adjacent to you. So please log out from one of the device. If you are not sharing from that device, please log out from that device so that only one device will work.
No, I have logged from my Apple computer only.
Okay.
Only Apple computer there is, even my mobile is also switch off.
धुमने सर
Yes.
बरं का सर काय होते ते एको येतोय तर आता ते तुमची स्क्रीन दिसताना काय होते 4 ठिकाणी दिसते तर स्क्रीन शेअर करू नका तुम्ही डायरेक्ट जॉईन आणि बोलायला चालू करा
Stop your screen share.
Okay.
स्क्रीन शेअर करू नका बोलायला सुरुवात करा बघू
Okay.
हा येस सर
Now?
नाही तरी पण एको येतोय हा नाही आवाजाचा
नाही एको पूर्वीपासून तुमचा फंक्शन एको येत आहे.
असं का हा चालू करा बघू ओके
फंक्शन पासून येतो माहिती मला काय कारण काय माहित नाही. Yeah. Is it okay now? Echo is still coming. What is the problem?
No, sir, there is no echo. You can proceed, sir.
No, echo is not coming. Okay, I can rejoin. Just solve the problem. Now, so many thanks for the management of institute as well as the Race Shikshan Sanstha. This is my second occasion to be with Race Shikshan Sanstha. First I was in Pune 2 years back, now in Karad. So already some light has been thrown on the IPRs and introduction to IPRs by the speakers and by Principal Sir. I will just rephrase the idea on IPRs because as we are aware, the intellectual property rights is a right given by the Government of India through various IPR legislations, and by virtue of that right and the right over the intellectual creations, the owner can have several benefits, including enjoying the IPR as property. It is just like any other property which you can enjoy. You can, of course, you own it, you can license it, you can sell it like any other property. The origin of all these IPRs is the human mind, creation of ideas in the human mind, which are manifested in various forms like patent, design, trademark, GI, etc. But there is no protection, legal protection in the idea itself. The person who will provide idea to anybody will not get any benefit of that, of the manufacturing of that idea in the form of any IPR. So person who has given guide, for example, who has given the idea to his student to do some research on this and that topic, and ultimately that research results in the thesis or any PhD work, then the invention contained in that PhD work is the sole property of the research student only. And research guide has no claim on that whatsoever unless otherwise specified, and it is treated as a joint work by the guide and student. And otherwise, student is the whole owner of the patent he created on the PhD work, like that. So the intellectual property is typical in this sense. The person who files first, for example in patents, he will only get the right and nobody else. The subsequent filing on the same invention will not get any patent right. So the manufacturer's idea is very important phenomena. How it is manifested, and as a patent, and then who files it first. These are two important factors. As I already said, the different types of IPR, patent, design, trademark, copyright, etc., they have a different scope, and there is no overlapping among as far as legal aspects are concerned. Patents are given for invention. This is a technical solution to a technical problem, and exclusive monopoly right for 20 years given to that. Whereas industrial design has no relevance to any technical functioning or internal mechanism, etc. It is given solely on the external features as it appears to eye and judged only by the eye. So eye is the sole judge whether that industrial design is new shape, pattern, ornamentation, configuration as compared to the existing design. So on the external features. Third is trademark, again has no relation to patent and designs. It is given for word, name, logo, etc., combination of color, etc., as applied to article of manufacture, and a separate right this way. Copyright, on the other hand, is given for artistic creations. It comes to existence as soon as the work is created, and geographical indication is altogether different right. Patent, design, trademark, and copyright can be owned by a single person or entity, legal entity, whereas geographical indication can be owned only by association of persons, not by individuals, because it's a community right. Other four rights, patent, design, trademark, and copyright, can be licensed out to third party, whereas GI, being a community right, cannot be licensed or sold to anybody else. If the association is dissolved, another association will take over as the proprietor of GI, and the persons who are producing that GI article, which is agriculture, natural, manufactured goods, they are called producers, and they are authorized to use the logo and the name of the GI register for the purpose of selling their articles or produces to their people. So these are basically distinct rights, distinct by their legal aspect, distinct by their scope, and distinct by the enforcement, etc. There is no overlapping. So when the news comes that Tirupati Laddus will be given patent on Ipr Awareness is considered for patent right, is a misnomer. They are coming out of the ignorance of the people to know exact boundaries of the patent. Is very important for the beginners. So when you create invention, there is no question of the design. Therefore, unless you come out the articles with their patented invention and marketing for the external features which appeal to us. All these IPRs may be present in single article. For example, when you purchase TV set, patent is for the innovations, and invention inside, trademark is for the name, design for the external features of the TV set, whereas copyright is for the booklet or leaflet of that TV set. These IPRs, and what was the situation in India before we joined TRIPS agreement? Because TRIPS agreement provides minimum requirement to be fulfilled by each member country in respect of formulation of the laws and implementation of those laws. For example, IPR laws, I mean to say, prior to joining of and amendment our laws from 2000 onwards. Particularly, Patent Act was amended in 2005, followed by prior to 2003 and 2005. There are significant amendments were made to Patent Act and rules thereafter. So before that, our patent law was very, very confined to legal requirements only. And after independence, till we joined this, between this period, the emphasis of the government was to create a local industry, protect local industries, and there was no much connection or joining with other multinational industries or like that. So whatever we were getting technology from the outside countries, we were implementing it by having factories and all that. So as far as IPR was there, there was little scope in that. We had a minimum number of patents in those areas, in those periods, and in each and every areas of the industry. When we decided, after making significant progress in industry sector, and we were ready to join TRIPS agreement, we amended our law, particularly patent law in 2005, whereby we provide patents now in all on fields of technology for all types of inventions, with few exceptions, for 20 years. Before that, the situation was really pathetic. In engineering sector, there was a protection of 14 years. And in chemical, alloys, food, and other related areas, alloys, etc., drugs, there was protection of 7 years. Patent office used to take 5 years, about that, 5 years for grant of patent. And you can imagine in the fields of chemicals or drugs, etc., no time for enforcement of granted patent was existing there. And sometimes patent was granted after 5 years, there was no scope for any enforcement. But the situation now is very different, and it has changed very fast from 2000 onwards. Now we are at par with TRIPS agreement. Our laws, all laws, patent, design, trademark, and GI have been amended to be at par with the world. But with patent law, now our Patent Act is very much in line with the global requirement, global patenting provisions. So naturally, when you are granting patent at par with the global IP regulations, there is increased number of foreign applicants coming to India also. So much so that before say 3 to 5 years, 80% applicants were being filed by foreign countries in India. But this was not a welcome situation at many countries, like particularly China's, European countries, and USA, etc. They were getting patents in India. Our Indians were lacking in desire to get patents here. And so the industry sector was more or less governed by by foreign technology. The situation needs to be increased. This was realized by the government very late. And now, full-fledged campaign for awareness and creation, or awareness of IP creation, but to patent filing has started during last 4 or 5 years. And recently, last year, the government of India has launched the IPR Awareness Program to motivate the people for filing more and more number of patents and get more and more patents to be competitive with your foreign counterparts, and therefore our awareness programs and encouragement of filing workshop, etc., are conducted in large number, and they are being conducted now also at all education institutes. This awareness program is a series of those awareness program on patents, as the government of India wants to be conducted at every institute for students and faculties who are competent enough to take patents and inventions like this. Now, why this IPR, the patent, design, trademark, are important? Because almost all countries are now members of TRIPS agreement. TRIPS agreement not only dictates the requirement of filing IPRs, but also how to deal with that, how the countries should deal with international trade, and how IPRs play a very important role in exchange of technology, in using technology internalization of the industries, etc. Therefore, in the industrial scenario, IPRs have obtained much importance, particularly patents, because when technology is transferred among the firms belonging to different countries, then IPR patents held by each of the counterparts are considered, and the value of this deal is defined based on that. Patents, as you may be knowing, that they protect new and inventive products. Therefore, whatever we are getting by our patent technology are better products, new products, advanced products protected by IPR. And after some time, the prices settle down, as happened in the case of, say, mobiles or technology or TVs, etc. Previously, they were very costly. Mobile, for example, simple mobile was costing 10,000 now. Now, advanced mobile now is costing 46,000. So, our life has been made very easier and very modern by virtue of the new technology coming out through patents. And more IP portfolio held by the countries now is symbolic of the wealth of that countries. For example, USA, Japan, South Korea, China, European countries, they have a large portfolio of the IPR, particularly of patents, and they are now dictating terms in terms of foreign technology coming to other countries. But with China is very strong by virtue of their IPR portfolio. So is USA, Europe, and say Japan, Korea, etc. This is evident from these figures. 2020 as compared to 2019. So China is 14 lakh patent they have filed. Is a growth also. US is distant second with 6 lakh around patent filing. Japan is again 3 lakh patent. Republic of Korea 2 lakh 26,000 patent. European EPO 1 lakh 80,000 patent applications filed during 2020. Germany 62,000, very distant, less from other 5 partners. And India is 7, with 56,771 applications filed. Of course, we are showing growth also 6%. And domestic filing is very significant now, it's 37%, but still less as compared to other countries which are above India. But it was 25,000 applications filed in 2007 or 8. Now within span of 12 years, it has become now 2.5 times. Still, we have to go a long way. We should be able to match other developed countries in terms of patent filing, patent grants, and domestic filing and domestic grant also. This is requirement, and therefore, the patenting activity must be encouraged in institutions where R&D takes place, where the students and faculty are engaged, and while they conduct research on any field, in any subject, there is a requirement to stop at steps and see whether my invention is worth patenting. Do that. If not, go ahead and do the invention, which may fetch you patent also. So nowadays, what is happening in most institutions? They are not bothering about any patent filing, etc. They are given some project work, there's some subject for their MTech, MS project or PhD thesis, and they continue to work on that by doing some literature survey, etc. But I don't think patent search is being conducted, because patent search is such thing where you get access to latest happenings in that particular field. You can decide what is happening in my field and what should I search, what should I undertake. If you have taken some topic which is already being handled by several inventions or several work, then deviate yourself and take the latest one in their field and conduct research so that you are eligible for filing patent applications. Now, what is happening? In India, IITs and other highly advanced education institutes, they produce so many graduates and technicians and engineers. What is happening? They go outside for their career development. they file hundreds of patents in that country, and they in turn those countries file in India to be enforced in India. So the patented inventions is a property of other countries, not by India in that case. Had it been the reverse one, the Indian scenario would have been different, and Indian R&D would have been richer in that we would be able to dictate scientific and technical competence to the world. This is not happening. There was a news a couple of days before that particular alumnus of IIT Kharagpur got 200 US patent filed in his name. He was working Samsung, the great achievement by that way, no dating down, but had he been associated with an Indian firm, things would have been most welcome. So this brain drain, of course, is there. When you become strong in R&D, strong in patent system, all these patents would have been filed from India, and our portfolio would have been increased. You can note down that Hawaii, Mitsubishi, Samsung, Qualcomm filed more international patent applications. International patent application is such that when you file in many countries, then you become strong enough to enforce patent in those countries. So these companies have filed so many applications that they are more than the whole of Indian application filing. This is not a welcome step. And 85% of our patent filing to 2020, what we have seen just now, 32 million, etc. So 85 are coming only from these 5 countries: China, US, Japan, Korea, and Ethiopia. We are 7th in the distant 7 rather. And China accounts for 45.7% total applications of this. This again, China is advancing in such a pace that they are present everywhere. If we cannot match China in that case, very couple of years, but we should try to file and get more and more patent in the country on various subject matters. That's why Indian government is encouraging filing in India. And government of India has also launched Atmanirbhar Bharat and Made in India projects and Made for the World project. These 3, what is the meaning of this? Because we have to depend on foreign companies to provide latest technology. For example, mobile technologies totally controlled by Chinese mobiles. This should be reverse. So we should be able to produce new and advanced product in India by way of patent technology, by way of becoming Atmanirbhar and Made in India plan, so that we do not remain the just importer of technology, but exporter of technology to the world. So that is the mission of Government of India, to be Atmanirbhar Bharat and Made in India, and all of us who are engaged in research must contribute to that. And whatever work you are doing in science or technology, you should ponder in between and think of whether you can file patent applications. And I can tell you that the patent procedures nowadays are very, very simple and almost 100% online. You are not required to go to, say, for example, you are from Karad, you did not go to Mumbai Patent Office at all or grant of patent. Everything you can do while in Karad, for example, or hearing and everything. And it is procedure simple, knowledge is ample enough available in website. Filing procedure are so simple, online filing. There are many, many patent agents to help you. Only requirement is that you should consider very seriously to think of filing patent applications. Now, why this happening? Why patent activity is less in India? There are some reasons we can visualize here. We still are not very keen about filing patent applications. There are various reasons for that. We have insufficient infrastructure. We have insufficient security in the job also, particularly in the educational field. And then you just are complacent by publishing papers, but you forget that by publish and you will peril, because the moment you publish your research papers, as told by previous speaker also, there is no chance for you to file patent application because novelty is not there. Novelty is very key factor for patent filing. your invention must be new. The newness means you should not publish it in the paper. But most of the faculty students, as soon as they do something concrete, they are in favor of publications and they lose the chance of patenting. Instead of that, you file patent applications, protect it, and you can publish it anywhere. Then you can have the fruits of your invention. In real sense, you can get the wealth generated out of that invention also. Of course, the public awareness needs to be created there. Most of the research remain unprotected and it is published. So there is a need for young people to think, to ponder, and then analyze their own journey of research and adopt patent filing in large number. Because at least if it is not commercialized, say for example, you patent after filing and grant also may not be commercialized because only 5 to 7% patents are commercialized. But still you get the credit of having patent in your name. And it is much more worth than one paper to your credit. In fact, one organization in Bangalore, they were giving in their CRs weightage of 3 research papers to 1 patent application file. And this should be done at all institutions, academic establishment, that patent filing should be evaluated separately as compared to research paper published by any individual. Not only that, when there are patent applications filed or patent granted to an institute, then there is a chance that your revenue will be increased by licensing on IPRs. You will be able, your institution will be able to attract more talent by virtue of your patent portfolio from the faculty, scientists, or students also. And your institution will be treated as a pathway for career development. And your institution will get prestige also. The institution may get funding from the industry, and their research program will also be enhanced in quality terms. You will be able to attract quality teaching faculty from industry, and then there will be better career opportunity for students and faculty because they will be absorbed in large numbers by virtue of patent environment existing in your institutes. But this is not happening at present, particularly in academia, where the industry and academic research persons, they are not coming together. There is no collaboration with the industry of the research personnel. R&D is going separate, research industry is going separate. They are pulling apart industries, just compression of stereotype working, whereas researchers are busy in publications. Now time has come that both academia and research industry should come together and have joint programs for industry-based R&D, commercialize that, and then have more patents and get the benefit for both. This time has come now. So what we can do, this is our sacred duty to contribute wholeheartedly to make success Atmanirbhar Bharat Abhiyan, because when you set up more and more industries, SME sector, that what government of India is contemplating, in startups, in industry also, all these new product and new process will come up. They will need protection through IPRs, and more IPRs should be protected, created, and then we'll be able to contribute towards Made in India and Made for the World program. With these introductions, I just say something about patent right now. You are aware, some knowledge already is there among the faculties there. What is the patent right? I will just summarize it. Patent is a statutory exclusive right. It excludes others. It means if you are patent holder, you have all right to commercialize and enjoy it. But others who do not have such permission from you cannot make, use, sell, or import such patented product or process without your consent. So this important right is granted for 20 years in India. And in lieu of that, in lieu of this important right, what you are doing, you are disclosing your invention to the government, because you are filing patent application which is statutorily published. There is no secrecy in patent application. Only up to 18 months secrecy is there, which is secret, kept secret by patent office. After that, it is published. After publication, it can be seen and used also for further research by third party. There is no restriction for that. There is no login for that. So disclosure of invention, disclosure of your R&D to the public facilitates knowledge dissemination to others who want to undertake research in the same field or improve upon their working, improve upon their product profile, etc. So dissemination knowledge is important, important function of the patent application, patent grant. And there are limitations to this slide, because when you say that patent prohibits others from making, using, selling the patented product, but there are certain provisions in the public interest, public health should not be hampered by your patented product. So government allows some use for the public interest. Government can acquire patent, government can use the patent, government can use license for the benefit of people also when there is a need like that. Like any other property, patent can be shared, can be licensed or sold. Also, an action can be taken against infringement also. So, these important aspects of patent are related to invention. So, patents are granted for invention, what we have seen. That is, quite often, this invention is technical solution to a technical problem. So, you are offering some technical solution to the technical problem which is existing at the time of filing of that invention. So, you have undertaken inventions for this purpose. So, your invention to be qualified for patent means what? It should be new product or process which should involve inventive step, and it should be capable of industry application. These three criteria, and no other criteria is there for patent grant, except of course two exceptions. Two other things are there, that there are legal requirements that you should be authorized to file patent applications, or like that you should be assigned or something like that. But apart from that, Patent Act provides only three criteria for qualification of the invention to be patented. That is novelty, inventive step, and competitive industrial applications. So you have to ensure that your invention is not part of the state of the art. Means it should not fall in the prior publication, prior use or prior work of the similar type of research work, invention, which is existing prior to date of filing. That is called state of the art. Second thing, it means novelty is that your invention should not be similar to the invention filed earlier. Second thing, the difference in the invention by your different from prior art should have some features. So your invention should have certain features which depict, which show technological advancement as compared to the existing knowledge. So inventive step criteria is stringent than novelty criteria. Novelty simply there should be difference from the prior art, and this difference should have technical features which are clearly to be stated in the patent application, make serially by virtue of experiments to be shown there. So experiments and your depiction of inventive step is very important part to show that your invention is inventive, and such inventiveness is also not obvious to persons in that. Means these flavors are very simple, that a very ordinary person having ordinary knowledge in the art should not think that I can also do it very easily. It is not obvious to persons in the art. So your invention should have technical features as advancement over the prior art, and your invention should not be very simple, that is obvious to persons in the art. These two criteria is for inventive step. Third is, invention should be capable of industrial application. The invention which is not useful in the industry is not granted patent. So what is novelty? Certain features of novelty I can explain to you. When you file patent applications, your patent application invention is compared to similar piece of the prior art which is existing prior to filing, which is readily available to public, not secret document. Secret document is not valid as a prior art. And you can make reasonable trial or experiment of invention before filing, provided you keep it secret. You can ask your friends advice that how will your invention work, but you should have faith in friend or your advisor They should not disclose third party. There should not be any publication or any exhibition or prior sale of your invention before you filing patent application. You should not give samples, etc. And your invention should not be available in public and known to public. If it is, say, somebody has done same invention and he has not filed patent application, rather he has preferred to keep it secret. And then after you make a same invention file patent application, that fellow who has kept such invention secret cannot claim that he was knowing earlier to your invention, because that prior art, although was there, was secret prior art, and secret prior art is of no consequence. When you are employer, when you are faculty, when you are researcher, or when you are working in any R&D laboratory also, you need to disclose your invention to your superiors. When you are written thesis or project work, you need to submit to competent authority. Such submission or such discussion with the seniors about your invention does not invalidate your patent. It is not prior disclosure. This is a very important thing to be noted. So when I say that there should not be any prior disclosure, there should not be any what you say, any prior publication, etc. There is one exception to this, for this. What is that exception? So this exception, that when your invention has been obtained by your fellow worker or third party wrongly, without you knowing about that, then the novelty is not lost. You can reclaim your invention by taking suitable steps available in the Patent Acts. Similarly, when accidentally or deliberately you display your invention in the exhibition notified by the government, and is published also as a consequence of that exhibition, or you research paper you present in the learned society and is also published, then or you take this trial also of invention. But after all this, if you file patent application within 12 months, then also novelty is there. This was experienced by me when I was in Chennai, when I was giving lecture about these particular provisions in the Anna University there. About 10 university professors from the chemistry, physics, and allied sciences, they had made prior publication of research paper in the journals. When I told them about this provision is existed under section 29 to 34 on the Patent Act, they rushed to file patent application because 12 months was not completed after prior display or prior exhibition, prior reading of the paper in respect of their invention. So they could file patent application, and some of them could get patent also. So this is a very important provisions, particularly for the academic people. Second, inventive step, as I told you, it is a stringent criteria which requires that technical advancement should be clear by your features, certain features of invention, and we should mention them in your invention. So you should compare your invention with the similar features available, and you have to show that how your invention is different in terms of technical features over and above that features. So systematic description of the inventive features, maybe more than one, in your patent application, followed by experiment to substantiate that declaration that my invention is inventive as compared to prior art must be there. So this was about the novelty inventive step and interest applicability as a criteria for getting patent. There are certain category of applications which are not patentable at all, and there are reasons for that. These inventions have been kept out of the patent purview for various reasons, being simple to anti-public, etc. We will see briefly them. This first one, your invention should not be frivolous or against the natural law. For example, machine giving more than 100% performance or any perpetual machine is not patentable. Second is your inventions, that is, the use of the invention should not be against a public order or say against a public morality, or your invention should not be such that it should cause human prejudice or harm to human life or plant life or health or the environment. So your invention should not be harmful to any life, either human, animal, or plant, or should not be against the public order. For example, invention filed for device or method for gambling is invalid and will not be granted, will not be considered. Similarly, patent filed for cloning human being or animals will not be considered. Similarly, any application made for device or method or committing theft or housebreaking is also not patentable. Similarly, any machine or method claimed for counterfeiting of currency note will not give you any patent. Third is discovery of any scientific principle is not patentable or formulation of abstract theory. Archimedes principle, superconducting phenomena, biometallic strip, all these are very great phenomena of their time. And they have revolutionized the human life. But as the discovery of these principles of abstract theory underlying these phenomena are not patentable at all. But any apparatus or appliances made based on it, and there are many such appliances or equipment made based on Archimedes principle or superconducting phenomena or biometallic strip, they are patentable. So, of course, you know this discovery, which is already existing in the Mother Earth, whereas invention involves human intervention also. Next section regarding drugs and chemicals, where suppose there is a patent out there existing on some substance, and for keeping that patent alive, what these multinational big companies do, they come out with a simple new form of that substance and claim patent for that. So thus, this new form is not patentable at all. Similarly, aspirin used for headache. Suppose somebody claims use of aspirin for gynec purpose or heart purpose, such new is also not patentable under the patent law. This section 3, subsection section 3E of the Patent Acts, that mere invention is a combination invention. You are combining two or more ingredients together. Then mixing of those ingredients should not be mere admixture. Means the ingredients should not show their individual properties in the mixture. This is admixture. When there is no display of such properties, individual properties, and the resultant mixture is showing different properties like soap, detergent, lubricant, then there is a patent for them. Soap, detergent, lubricant, in this compound cement also, the ingredient properties are not present. So these are patentable, whereas sharbat, for example, is a mixture of sugar, colorant, and water, is not patentable subject matter. The similar in engineering field, if you are using more components, 2, 3 or more also, and you rearrange them and duplicate these known devices in such a way that they are independently functioning. There is no combined effect displayed there, then there may not be patent. For the purpose of getting patent or combined invention, by arranging these known devices, there should be a value addition to the result for getting patent. This related is a method of testing. Was there as a non-patentable invention in the earlier act. Now it has been deleted. It means that all the methods of testing in physics, chemistry, or any biology, in any field, novel method, if it is novel method of testing, is patentable subject matter now. When I say that there are many, there are categories for which patent are not granted, don't get discouraged. There are many patents available in this category also. For example, methods of agriculture, horticulture, there are no patents because these farmers' interests must be taken care. However, there are many patents available in this field also and other categories also. For example, there are many patents for herbal medicine, cosmetic, perfumes, oils, syrups, essences, flavoring agents, and many substances like that. So when we say that there are no patents in method of agriculture, it is half truth. Only certain patents are not granted, but there are many patents which overcome these objections are grantable patent subject matter. So doctor's knowledge in next subsection says that doctor's knowledge is not patentable as to how the doctor will save the life of patient. by, for example, fixing balloon or balloon stent, etc. But there is no patent for the doctor's knowledge or treatment methods also. But any apparatus, biomedical equipment, etc., they are patentable subject matter. Plants and animals in whole or any part thereof are not patentable, obviously, to keep away the life forms from patenting. This section 3K is very important, which says that mathematical method, business method, algorithms, and computer program per se are not patentable. What does it mean? When invention is not computer program per se as such, when there is a value addition, when there is a technical effect, this one, when there is technical, this particular thing, this, then computer program along with hardware become patentable. This has been clarified by the new guidelines of patenting of computer-related invention, as well as court decisions, Delhi High Court decision, that whenever there is the technical effect or technical contribution by combination of hardware and software, patent may be there. So these are the copyright subject matter, literary, dramatic, work, etc. These are mental games which are not patentable. Presentation of information and topography integrated circuit, these are subject matter. Of course, topography integrated circuits, semiconductor law is there. But last subsection, 3P, that is traditional knowledge or product based on traditional knowledge. When is the aggregation of or duplication of traditional knowledge? Suppose you get 3 herbs, mix them in powder or any other form, they may not be patent unless you show that there is a value addition to the final compound, which we call synergistic effect. When there is value addition, then the patent based on traditional knowledge can also be given. So we have seen that there are many benefits coming out of patenting system. It gives valuable guidance for planning R&D or for your R&D program. It's a tool for international trade. Patent gives cheaper and better products. Patent is a measure of company's success. And then, most important thing for you is for knowledge dissemination or information dissemination. The patent disseminates information great way. So much so that when you plan new research, new project, new patent-related invention also, and if you conduct prior research, you will get that what is available on subject matter, and therefore you did not reinvent the wheel. When wheel is there, you avoid that, go ahead further. That is a message given by these prior publications. In this way, patents are stepping stone for further research. Published patent applications, I told you that patent applications as a rule are published by patent office. There is no secrecy. So this patent applications published or patent grant published is a virgin knowledge available with the tip of mouth. Their virgin knowledge is available in the ocean of scientific and technical knowledge, and everybody should get benefit of that. Patent have really revolutionized, provided very comfort to our life, and a very simple example for that is this. When women in villages were using this chakki for grinding of grains, now machine has come, homemade chakki or machines, where the large scale labors of women folk can be avoided. The patent system gives you very great benefits when you are startup, when you are MSMEs, when you are women inventors, when you are education institute. All these categories are treated at par with national sector. 80% fee concession is there. Apart from that, there is a provision that your application filed by all these startup, MSME, then your women inventor, as well as education institute will be examined expeditiously so that you can expect patent grant within 1 year of filing your application in most of the cases. This is by virtue of amendment recently enacted by the government of India. The word of caution for you that it is first to file patent grant in India. So Alexander Graham Bell We know that he was inventor of phone, but at the same time, another lady filed a same application which was not considered for the grant of patent because she filed application few years later. This phenomena which happened in 1876 also applicable now also. Second myth is that you think that for patent grant you require great invention. It is not that. More than 95 patents are granted for improvements. Very simple. For example, if a main patent is on ballpoint pen, the variants more than 2000 is old data. More than hundreds of ballpoint pen technology have been patented. Pen ink, pen refill, pen body, and smooth writing process also like this. So there is another myth that it needs certain education, certain age. It is not that. Age is no bar by patent filing. Similarly, education is not. The cycle mechanic can file patent application if he comes out with improvements in cycles, etc. This boy of 9 years, he invented 6-player circular chess at the age of 9 and got patent for that. He also got patent for 12 and 60-player chess, and he was honored by Honorary President of India. He was also winner of several other awards and National Award for Outstanding Creative Child. He was physically disabled. It's very important. So there is no bar of education, no bar of age, etc. for filing patent application. Whatever you are doing at your stage is just enough for filing patent applications. These are important inventions from India. Is ink which is used for voting, Lily maker, simple clip. These have been used. So I am going to stop here. And then for patent applications, which Pallavi will tell you very aptly what you should do for patent filing, etc. And then only thing, some words of cautions for you. You should conduct prior art search before undertaking any patent filing, because if you do patent filing without conducting reasonable prior art search, you are likely to land in infringement of others, or you are claiming something which has been claimed earlier. Second thing, when you are doing some your research and which is partly complete, you are expecting complete result after some time. Don't delay filing of patent. You file at least provisional patent application and stake your claim for patent, because your protection will start from the date of filing provisional and you can file complete petition afterwards. If you delay it, then somebody else will come and she will file patent application, leaving no chance for you like this. So if you do not conduct prior art search, then your efforts are also going to be wasted, because average of 25% R&D efforts are wasted because they are based on already done invented matters and they are of no use like this. So I think I have crossed my time and I can stop here. Thank you very much. Now I would like to invite any questions, or questions can be taken by all three of us at the end of program also, whatever is decided. Thank you very much.
Thank you, Dhumane sir.
Yeah.
Is there any questions or doubts from participants?
Yeah, you can ask. Where is that? Okay. How can I increase the size of this? Yes, please go ahead. Go ahead with questions.
Dhumane sir, it seems that there are no questions in the chat box.
Okay. Yeah,
Can we
sure.
move ahead, sir?
Yeah, I can do. Okay. Yeah.
Yes.
So thank you very much for patient listening. And
Thank you,
there.
sir.
Yeah.
I request Mr. G.A. Kadam for vote of thanks. Over to Mr. G.A. Kadam, sir.
Thank you, sir. A very good afternoon to all of you. It's me an immense pleasure to deliver the vote of thanks for this event to all dignitaries assembled here. I would like to thank our chief guest, Dr. Dhumane sir, who honored these functions with his inspirational thoughts and valuable guidance regarding the IPRs and patent filings. And I'm sure your guidance, sir, will be useful for all these participants in their professional career. So thank you, sir, once again. Thank you.
Thank you. Thank you.
Thank you, Kadam sir. Now for session 2, I request Ms. Gatge madam to introduce the expert. Over to Gatge madam.
So good afternoon, everyone, and thank you each one of you for attending and joining us today. We are very pleased to have with us Ms. Pallavi Kadam ma'am, who is founder of IP Adventure and designer partner. Okay, IP Adventure is IP filling services in assisting India as well as in outside the India. She has conducted various IPR awareness workshops, and she is also a patent agent assisting in innovator for drafting and filling prosecuting patent. She had also attended various IP related training programs. She has also got prestigious DST, TIFAC, Women Scientist C scholarship. She also associated with various institutions like Patent and Design Facilitator under SIIP scheme, Lupin Research, Pharmaceuticals, SciH Abstract, Glenmark Research Center, and NCL Pune. Now, ma'am will give us some insights about intellectual property right as well as patent applications. We are eagerly waiting for you, ma'am. Over to Pallavi Kadam, ma'am. Thank you, everyone.
Virtual participants and Sadguru Gadage Maharaj College faculty staff and all my friends and my mentor Dr. Dhumane and my partner Shalata. I'm starting my presentation. Before moving ahead, it's a Saturday, wonderful Saturday winter afternoon. I don't want to, keep on stressing you. More serious aspects of intellectual property rights. Dhumane sir has opened this podium very nicely. He has introduced all the IPRs very nicely, and he also differentiated on the trademark, on the intellectual property rights in terms of its ownership, filing procedures, and ownership. So let me go ahead and give a brief.
Kadam madam,
Yeah.
your sound is not clear, madam.
Hello. Am I audible now?
No.
I'll.
Yes, it's audible.
Is it fine, sir?
Yes, madam.
Okay. A very warm good afternoon to all the participants. Sir. Indrajit, sir. Hello.
Yes, ma'am.
Hello. Am I audible now?
Yes, madam.
Yes, ma'am, you are audible.
podium very nicely. He has introduced all 7 types of IPRs, very well recognized and granted by Government of India. And he tried to make the differences as in terms of owner filing procedure, etc. Now, few netiquettes. I'm going to put off my camera while presenting my. If the participants they have the queries, they can put their queries in the chat box.
Madam, your sound is breaking, madam.
This issue is with the Zoom platform. Do you want me to rejoin? Hello. Hello. Am I audible, Shalaka? Okay, okay. I hope my voice is audible to all
Yes,
the.
yes, audible, audible.
Okay, okay. So I'm going to put my camera off while my presentation. And if the participants, they have their queries, no, they can post in the chat box so that my partner Shalaka or my mentor, Dr. Dhumane, will try to resolve your queries, or will take all the queries in the last, before closing this session. Since it's Saturday afternoon, I just want to give some sort of, entertainment kind of thing, so that this infotainment part will start while sharing this important piece of knowledge of IPR to all the participants. I'm going to play one of the best videos I ever saw on IPRs or innovations. Why innovation is required in India. My screen is visible. Hope my screen is visible to all of you.
Yes, yes, ma'am. It is visible.
I think there are no issues while viewing this video. I'm moving ahead to my presentation now. Hope my screen is visible. Is it visible, sir?
Yes, madam. It is visible.
So, you all are welcome to the SciPAM's Innovation Week celebrations, which is being celebrated during 10th of January to 16th January. This is our second innovation celebration along with SciPAM MNLU. Thanks a lot, Dr. Dhumane sir, for connecting us to S.G.M College. And I'm really thankful to S.G.M College for making this virtual platform available for such type of innovation week celebrations. So I'm moving to my presentation. So this is my introduction as rightly introduced by the college authorities. So this is the disclaimer I'm putting here because I'm using few IPRs filed by the innovators or the traders for introducing their own intellectual or innovative work in the course of trade. I'm using them for educating you all people. So I'm not going to gain any type of monetary benefit out of such use. So we have devised 4 Ws. Even there is 5th W also. Since there is a short of time, I have removed that 5th W. Why to study IPRs is really important. As sir introduced about the global ranking of Indian filings, may it be patent or copyright trademark, with respect to the developed nations. He said that we stand the 7th in terms of all these filings. China is the, no doubt China is the leading country. Then we need to understand when to start understanding the value of IPRs, when to start filing patents or copyrights, and when to start, educating the common people. As sir rightly told, IPR regime is totally mingled with the creative mindset of the common citizens. It does not speak about the educational qualifications or the age bar or the gender bar of the creative people. So it is really very important to start this IPR education as early as possible in may it be in the schooling or may it be in the graduating stage. And we all gather here for the second point. What to study, it takes time. So I just pulled out only copyright matters. I didn't include rest of the regimes here to make my presentation a bit short. And why to study patents? That is one of the most important aspect. It is quite often asked by the institutes during our awareness sessions. So this is the typical scenario we come across on a daily basis. So my client, they come and ask whether they can patent their copyrighted trademark or not. So being in the developing phase, we as Indian citizens, we are not much aware. So if the same question is arising in your mind, then we all need this class. Just note that I'm sitting on this part of the table. I was sitting here also in the year 2015 when I started to study IPR and all that. Slowly I gathered knowledge and slowly I started to practice in this field, and I qualified this patent agent qualification, and myself and Salaka, we had a similar kind of journey to reach to this IPR coach status, and now we took it very seriously for educating the common citizens or the students or the faculty members in terms of IPR regime. So this is the human brain, which we feel that it is a highly evolved brain as compared to the other species in this globe. So whatever intellectual creation is arising out of this human brain, these are supposed to be the intellectual properties. Then slowly we are going to see all the 7 types of IPRs here. As sir informed you all and introduced about all these things.
Pallavi,
yeah,
slides are not moving.
Okay. Now they're moving, Shalaka?
Yeah, it has come to the first slide.
You start clicking on
Yeah, you start clicking on it.
this picture slide.
Now is it visible?
Yes.
Yeah, it's visible now.
Try to move.
Click on that slide so that,
Ah,
yeah,
yeah.
perfect.
Sorry for this sort of disturbance. Daily we are using sorts of platforms and we are quite stuck up with these issues. Sorry, I was referring to this slide earlier. So in the year 2015, myself was sitting here and I got education about this IPR at RGN IPM and Venture Center and all that, where I got thoroughly educated in terms of this IPR education. Now I'm sitting on this left part of the table and I'm educating the clients or the stakeholders of this beautiful IPR regime. So this is the slide I was referring to. This is the human brain where all the intellectual creations are arising out of these mindset. And it doesn't at all speak about the educational qualification or the age bar or the gender bar. So the whole IPR regime is talking about the human intellectual efforts. The human is taking place. May it be for the technological development or may it be introducing in the trade or may it be related to some copyright related aspects or may it be related to the visual effects about which sir was referring to the eye, the design part which appeals to the eye, not rest of the part. So slowly I'm going to introduce all the types of IPRs and I'm going to take a bit depth about the patents only because I'm running short of time. So trade secrets, patents, trademark, integrated circuit layout, geographical indication, copyright, plant varieties, industrial designs, and traditional knowledge. These are the all types of IPRs widely known. Now we'll be talking about patents, trademark, geographical indications, copyright, plant varieties, and industrial designs a bit. And rest of the IPRs like trade secret, traditional knowledge, and integrated circuit layouts. I'm not going to cover it because these are not the subject matter of today's discussion. You all are being in the educational institutes, you might be referring to patents in depth or on a daily basis. You might be carrying out research or some innovations, or your students, they might be coming up with new ideas. So how to deal with these patents is the sole topic of today's discussion. So this is the home page of Indian Patent Office, which divides the intellectual property in two main types. First is the industrial property and second is the copyrights and related rights. So industrial property, it has been again categorized into various subject matters like industrial designs, which appeals to the eyes of the consumers or the end users. So the shape of this Coca-Cola bottle, it has been registered under Industrial Designs Act 2000 in the Indian legislation. So patents, they cover the technological innovations, inventions, or the functional improvements, and they are being registered with Government of India at Indian Patent Office under Indian Patents Act 1970. Third industrial property is the trademark. You might be looking at this Coca-Cola word, the way Coca-Cola company has written this script of Coca-Cola with some color combination, with some typical style of the writing of these two words. So these are protected under trademarks. So when you want to introduce your own brand, your own product, or you when you are going to render some services to the end users, then you need to protect your brand name, or the way you write, or the way you depict the color combination of that particular word or the logo or the image. So it is being covered under trademarks. Then trade secrets, these are, there is no separate law in India. Common codes of law, they will help you to protect these trade secrets. Then comes the geographical indications. As informed by Dr. Dhumane, geographical indications are the community rights. So earlier 3 rights, industrial designs, patents, and trademarks, they may belong to individuals or the employers or the group of persons, group of inventors. But geographical indications, they are solely given to a particular community where the intellectual efforts they have been taken for growing certain type of fruit or making certain cloth or making some sort of jewelry, and these have been passed on from one generation to other generation, like you can see the Kolhapuri chappal or the Kolhapuri saz. So geographical indications, they belong to a particular community, and sir informed that you cannot assign these rights to someone else. So fifth type of industrial property, which has a separate act, is the layout design of semiconductor integrated circuits. So the innovations carried out on semiconductors, they can be registered with Government of India. Next, last IP comes the plant varieties and farmers' right. So as innovators or inventors, we keep on carrying out lots of work in our college days or in universities days. What about the farmer who is plowing the field and who is innovating a particular variety or carrying out hybridization and coming up with new seed varieties? Then how he can deal with his intellectual effort? So it is understood by the Government of India under Plant Varieties Act, and the same act, it talks about the farmers' rights as well. Whereas the rest of the acts, they don't speak about the owner's rights, like industrial designs and the owner's rights, or the patents acts and the inventor's rights. But since the Indian economy is based upon the agricultural sector, and the important stakeholder is the farmer, and he or she should not be exploited by the giant seed industries or the giant outside seed organizations, then certain types of farmers' rights have been mentioned in this Plant Variety Act. The second type of intellectual property is the copyrights and the related rights. So I'm moving on to next slide. So this is the homepage of Designs Registry of Government of India. So many inventors, they come to us and they say that they want to file a patent. But when we talk about their invention, or when we go ahead with the discussions, then we find out that this is the subject matter of the design. So I'm going to show you a granted design certificate, and this certificate has been given to the applicant for designing this unique stormwater drain grating. So many of the times it happens that the applicant comes to us, they say that they want to file a design, but when we go ahead with the discussion, then it is the subject matter of the patent. So what we found out is that the people are not aware about their own creations. And even sir also said in his initial introductory remarks that people, they should know that whatever is coming out of their brain and they're carrying out the research, then they should know where to go and why to file and how to file. This is the patent office website. So this is a granted patent, and he is the youngest inventor with whom we worked for the last 2 years. And Shalaka is going to tell you the short story about this inventor in the pictorial or the video format. This is the trademark registry of Government of India. And this is a recently granted trademark to one of our applicant for this particular logo. The way the applicant devised these color combination, written and put imagery effect in the minds of the end users. This is the Geographical Indications homepage. This is the Geographical Indications granted certificate to the Odisha Small Industries Corporation Limited for this unique Rasgulla. This is the plant variety and farmers' rights page. Earlier, all the IPRs, they come under Department of Commerce and Industry, but this Plant Variety Act, it comes under the Agricultural Ministry of Government of India. So this is a granted plant variety certificate for this Arka Ajit unique and novel garden growing tree. This is a copyright homepage, Copyright Office homepage. And this is a recently granted copyright to one of our applicants for his literary work for his book. This is the Semiconductor Integrated Circuits Layout Design Registry, where they accept the innovations carried out on the integrated circuits. Next W is when to start. There is a famous Chinese proverb, the best time to plant a tree was 20 years ago. Similarly, what was the best time to understand IPR is long ago. And the second best time is now in terms of planting new trees. Then similarly, if we correlate this proverb with our IPR regime, the second best time is to understand now all the importance of the IPRs, and you start utilizing it, and you may get commercial benefits. How you can get the commercial benefits from filing patents, Chalaka is going to inform you again one case study. This is the Indian IPR Legislature. You can understand all the Government of India is keenly improving on all the aspects of the IPRs in order to comply with TRIPS, and slowly and very strenuously, the Government of India is implementing all types of regulations and putting rules for identifying, for registering the various types of IPRs. You can understand the pace of this work slowly. That 1852 Patent Act was introduced by the Britishers, but in the year 1970, the actual Indian Patent Act was enacted. But now, if you see the Biological Diversity Act, it has been introduced in the year 2002, and the Biological Diversity Act, it came into the same, it started to enact in the same year. So IPRs are now the important tools for all the stakeholders, for all the common citizens of Indian territory. So what to study is very important. We need to understand what all are the important forms of IPRs and what is the particular subject matter of all forms of IP. Since there are 7 types of IPRs widely registered in India, I'm not going to take all the types in detail, but I want to just give a brief introduction about the copyright. So how the copyright, what type of subject matter the Copyright Act protects in India. So basically there are 7 types of works which can be protected by copyrights with the Government of India. These are the literary works. It may be a dramatic work. It may be an artistic work like a painting or a sculpture or so, and cinematographic films. Then musical works, you can get copyright protection, then sound recordings and computer software. So computer software is the 7th type of category for copyright protection. So there is a misconception that computer softwares are patented in India, and computer softwares, they are not the subject matter of copyright. But mind well one thing, computer softwares, these are the algorithms which are supposed to be covered by copyright regime. And if that algorithm is mingled with some type of or it is complied with some type of tangible hardware component, then it is a subject matter of component patent. So we are going to see why to study patents, because you all being in the educational academic institutes, you are dealing with research on a daily basis. and you are interacting with the creative students on a daily basis. So if you patent a particular technology, then you have to disclose the whole invention to the government of India, and in return to this, the government is giving you patent rights. There are certain steps which Shalaka is going to inform in brief how a patent is filed and how the grant is given by the patent office. By disclosing your invention, you are safeguarding the invention that so that no one should copy or sell or use your own technology without your permission. And if you want to give the permission, you in order in return you can demand some certain monetary benefit to the particular third party. This is the commercial benefit of that patenting thing. Then by patenting, the government wants to encourage the innovative development of our nation. Then you can enter into various types of licensing activities for generating some revenue to your own patented technology. Then this is the economic model widely known in the widely known as the global driving engine for growth. If a particular country has best practices and best regulations of IPR, then it is understood or it is known that the country is innovative. Why it is so? Because knowledge is available abundantly with a click of my mouse. And if you want to innovate in one of your subject area, then you need to understand why IPRs are there and how you can accumulate your own innovation by protecting with any one type of the IPRs. Then it is supposed that a global yardstick is used for measuring the country's innovation. If the country has its own IPR regulations and best practice methods, and the people are there coming ahead and filing their own IPRs, and they are getting good monetary benefits. So this commercial benefits, they are the global driving engine for growth of our nation. So this is the famous proverb by Dr. Raghunath Mashelkar. He always says that first file a patent, then publish your journal article, and automatically you will be prospered. Many of the awareness sessions, so we try to bring the inventors, but since it's an Innovation Week celebration, we didn't have any time slot available for interacting with the inventors. Then in such during such interviews or such conversations, you will be able to understand how they took proper efforts in the initial stages of development of their technology, and how they have filed a patent, and how then they went ahead in publishing a journal article, and how they got prosperity. But in usual sense, the academic people, they are in quite urgency to publish their own journal their own work in the journal articles, and then they go ahead for filing patent. And then the novelty aspect, the three criteria are there for eligibility, for being eligible for patent regime. Is the first one is the novelty, second one is the inventive step, and third is the commercial applicability of your technology. Then once you publish your own work in journal articles, then this novelty of your particular work, it gets killed or it is nullified by your own journal article. So if any one of you is planning to publish a journal article, then you first try to file a patent, maybe with help of any patent agents, or on your own also you can file a patent. If you need some guidelines or some tips on how to file a patent, you can approach us, myself or Shalak or my firm, anytime. Will help you to understand how a patent is filed by the own inventor. Moving ahead to differentiate why patenting is required first and why not publishing in the journal article. This type of patenting will help you to protect your own exclusive rights and stopping others from using your own technology. Whereas if you file a journal article, if you publish a journal article, there are no legal rights identified for such publication. And the second important thing is during patent regime, this invention is not available for others to copy. But whereas the whole technological features or all your steps or for all your processes or products, they are available in the journal articles. So the novel aspect of your invention is totally lost by this journal article publication. As I said earlier, you can enter into various arrangements like licensing, selling your own invention is possible due to prudential technology transfer mechanism of the patenting regime. Whereas the journal articles, there is no such opportunity for gathering some revenue out of your technology. So these are the basic things I wanted to highlight to you all. This is the end of my presentation. If anyone has their own queries, they can post in their chat box. Soren, madam, I'm stopping my presentation and my talk here.
Yes, madam. Okay.
Okay,
Yeah.
madam.
Yeah.
Thank you, madam. Now I request Mr. G.B. Gaikwad for a vote of thanks. Over to Mr. G.B. Gaikwad, sir.
Okay, good afternoon, all of you. It is my immense pleasure to propose the vote of thanks for the session 2. Thank you so much, madam, for your gracing us with your valuable information about the patent, copyright, trademark, and plant variety, etc., etc. On this one-day e-workshop on the IPR Awareness Program. Thank you. Thank you so much.
Thank you, Gaikwad, sir. Now we'll move towards our session number 3. Now I request Dr. S.B. Madke, sir, to introduce the expert. Over to Dr. S.B. Madke, sir.
Good afternoon to all. Today we have a special guest for our workshop, Ms. Shalaka Tolle from IP Adventure Pune. She is a certified Indian patent agent. She has expertise in patent drafting, filing and prosecution, and trademark searching, etc. She is Bachelor of Science in Chemistry from Mumbai University and did Masters in Inorganic Chemistry from Institute of Science, Mumbai. As she is from chemistry background, she has expertise in some analytical techniques such as LCMS, HPLC, GC, and IR spectroscopy. She is co-founder and practice head in IP Adventure. She worked with many famous institutes like SNDT University, Godrej, NCL, etc. Further, she is recipient of Women Scientist C Scholarship. With this brief introduction, I request Ms. Shalaka ma'am to please share her expertise in intellectual property rights with us. Thank you, ma'am.
Thank you so much, sir, for introduction. So, Principal Rajmane sir, my mentor Dhumane sir, Vice Principal, IQAC Coordinators, Head of Physics Department, Institute Innovation Council. I thank you all for giving me this opportunity to present my knowledge here or share my knowledge here. Now, till now, we have seen theoretical knowledge or theoretical information, what are intellectual property rights, how they are enforced, what are 7 types. and how they are how the different acts or statute control the enforcement of these rights. So these all, and what are the different subject matters which go under these different categories of intellectual property rights that we have seen. Now, as in the college, we have a theory part and a practical part. So I'm going to focus on some kind of practical information. So how we have dealt, or how the inventors approach us, and how we guide them, or what is our role rather to categorize, or to help them categorize their creativity into different categories. So there are certain budding entrepreneurs who approach us, so they want to protect their name of the company. So how to guide them? So protect it under trademark, or they should protect it under patent. So this being an IPR coach, we guide them in this matter. Similarly, as I am me and Pallavi are patent agents. So in our introduction, it was said that we are registered Indian patent agents. So what is a patent agent? What is the role of a patent agent? So we saw one slide where one person was sitting on the other side of the table, and he was approached by certain inventors or certain creative people, and they were not aware what kind of my creation, how to protect that creation, how I should have the sole rights of my creation. So our role, being a patent agent, our role is to be a mentor for inventor and guide him, and provide every kind of support from patent filing till the grant of the patent. Now, I'm not going to show you any kind of theoretical part, but I'm going to tell you two stories. So how the inventors approached us, and how we proceeded till the grant of their patents, and at what stage they have progressed. So I'm going to share our journey with these inventors. Now, before that, I'll share one video. So as Pallavi said, we have our youngest inventor whose patent is recently granted. तो एक college pass out मुलगा आहे, engineer, आणि without accepting high package jobs, he decided to chase his dream and do research and file a patent and proceed till grant. आज त्याने स्वतःची प्रायव्हेट लिमिटेड कंपनी काढली आहे, आणि ती प्रायव्हेट लिमिटेड कंपनी त्याने स्टार्टअप म्हणून रजिस्टर केले, so that he can avail all the facilities available, or की जे काही स्टार्टअप साठी आपल्या इंडिया मधनं फॅसिलिटीज आहेत ते अवेल करण्यासाठी त्याने आपली एक स्टार्टअप फाईल केले, रजिस्टर केली. सो फ्रॉम एन इंजिनियर पास आउट टू अ company's director, this is his journey, and we are going to see how he proceeded. So I'd like to share the video which will briefly explain you what exactly is the invention.
Life is a precious thing which is gifted to us by God. So it's our duty to prevent and save our life. As we all know, everyone on this earth can survive for a long time, but due to some lack of facility, we fail. Taking an example of an ambulance. Sometimes we see ambulance users stuck in traffic light, but that time we are helpless. As sometime other signal light is green and ambulance is stuck in a red light. And sometimes there is too much conjunction in the same lane. Or you must have seen a patient lying on a stretcher without any personal data and given a normal treatment. At this condition, usually hospital used to connect with police and waiting to get details from police station so that hospital can inform the patient family. So to avoid all this, we have implemented system and method for minimizing pre-treatment time for a person in casualty in your habitus environment. So let me explain you how our system works. As we all know, traffic light function normal in normal condition. As soon as when ambulance with patient moving towards the hospital or without patient moving to the incident place, which is detected from X distance before the traffic junction. Signal for that road will turn green for X time till that ambulance passes traffic junction. And then signal will resume to the normal function. Condition 1. If another ambulance is detected on the same road and the signal remains clean green till the second ambulance passes. Condition 2, if suppose two ambulances are detected in opposite lane, then first in first out priority will be followed. That means ambulance which is detected first, that route signal will be green for X time till that ambulance passes, and then another route signal will be green after the first ambulance passes. You might be having a question in your mind that how ambulance is identified. Each ambulance will be associated with the unique identification card with unique number which says ambulance ID. When someone calls on 108 from the incident location where incident has taken place, then the system admin, i.e. control room, will search for the ambulance, and whichever ambulance is free, that ambulance will be assigned for the duty. This will get updated on the server. In short, ambulance will be assigned with the duty ID. When the ambulance will pick up the patient unique ID, for example, Aadhaar card number, will be obtained from the biometric scan of the patient. This will be updated on the server. Patient fingerprint is not limited to only fingerprints, but it also contains iris scan, face scan, etc. will be scanned and associated unique ID for the person will be fetched from the server. Multiple biometric scanner, LED screen, mini computer, and communication unit to connect with the server will be used here in the ambulance. So now, along with the duty ID, patient ID will be associated with the ambulance ID. At the same time, a notification will send to the hospital and hospital will be calling to the patient family. And also family will be notified with location of the hospital and doctor will be notified with the medical history of the patient. So there will be no more delay in the treatment. When the reader will detect an incoming ambulance, it will check from the server if any duty ID is linked with the ambulance. If it is linked, then only the signal controller will be triggered. Otherwise, normal signal function will be observed. Here, an internet communication unit will be required. The duty ID and other details will be reset to default when the ambulance reaches the hospital with the patient. This will be done by receiving an authority at the hospital. Each activity on the server will be recorded with timestamp, and all the transaction and the communication are taking place through the server. Each action will be recorded on the storage unit. Local storage unit can be deployed on the external SD card module to log the activities. This entire statistical log of activities will be available to the concerned authorities if required in the future. I hope you understood about our system. Thank you.
So we have seen this video. Now I'll explain you what is exactly the invention is in brief. So पेटंट म्हणजे काय असतं बेसिकली इट इज अ प्रॉब्लेम सोल्युशन रिलेशनशिप. म्हणजे काय तर आपल्या डे टू डे लाईफमध्ये वी कम अक्रॉस मेनी प्रॉब्लेम इन द सेन्स दोज विच मेक अवर लाईफ बिट डिफिकल्ट, बिट टायरिंग. Maybe we will take more efforts, will take more time. So our life is bit difficult, and this is the problem and the solution which will make our life easier. Like nowadays we use washing machine to wash our clothes. Earlier we used to wash it with our hands, but then if the quantity of the clothes is more, then the efforts required are more. It is more tiring, time required is more. Nowadays in this fast life we require to do these tasks in very short period of time, and our human intervention should not be there. So washing machine is the solution to that problem. तसंच ह्या केसमध्ये पण प्रत्येक पेटंटमध्ये ना प्रॉब्लेम सोल्युशन रिलेशनशिप असतं. कोणता तरी एक प्रॉब्लेम तुम्ही आयडेंटिफाय करता तुमच्या लाईफ मधला आणि मग त्याच्यावरती रिसर्च करून सोल्युशन काढता. सो ते सोल्युशन मे बी इन द फॉर्म ऑफ अ प्रोडक्ट ऑर इट मे बी इन द फॉर्म ऑफ अ प्रोसेस. सो त्या दोन्हीचं आपल्या भारतामध्ये प्रोडक्ट आणि प्रोसेस दोघांचंही आपण पेटंट घेऊ शकतो. सो तुमच्या कॉलेजमध्ये एक इन्व्हेन्शन इनोव्हेशन सेल काहीतरी इन्क्युबेटर सेल आहे मुलांसाठी, मुलांना रिसर्च मध्ये प्रमोट करण्यासाठी. तर मी तुम्हाला तेच सजेस्ट करेन की ह्या फॅसिलिटीचा पुरेपूर वापर करा आणि रिसर्च करा. आता ह्या सेशन नंतर ऍटलिस्ट IPR म्हणून काहीतरी आहे असं तुम्हाला कळलं असेल तर या फॅसिलिटीचा तुम्ही वापर करा आणि तुम्ही जास्तीत जास्त तुमच्या कॉलेजमधनं पण पेटंट्स होऊ देत, ट्रेडमार्क्स होऊ देत, कॉपीराईट्स होऊ देत असं मी आशा करते. बिकॉज दिस इज द सोल इंटेन्शन ऑफ दिस अवेअरनेस प्रोग्राम. आता हा मुलगा जो आमच्याकडे आला होता इंजिनियर पास आउट असलेला, So what he was doing, एकदा तो इंटरव्ह्यू वरनं परत जात होता घरी, and then on the way he saw that one ambulance was stuck up in the traffic, and then he got worried कि the patient in the ambulance will not be able to reach hospital within time or at the shortest time, because why? Because of the traffic congestion. So how to proceed further for this, or how to solve this problem rather. And many a times, another thing is that many a times what happens, the patients or the patients who met, or persons who met with the emergency situation or met with accidents, so they are not in the state of telling the medical history. Many people are suffering from diabetes, heart diseases, and then they met with accident, and then they are carried to the hospital, and if they are having such kind of pre-medical history, proper medication has to be given, or if they are allergic to certain medicines, then the healthcare professional or the doctor who is going to operate or treat that person should be aware of this pre-medical history, की त्या पेशंटला काहीतरी प्रॉब्लेम आहे आधीपासून, किंवा तो ॲलर्जिक आहे, सो हे मेडिसिन्स त्याला नाही दिले पाहिजेत, ही सगळी माहिती त्या डॉक्टरला असली पाहिजे, विच इज नॉट देअर, विच इज नॉट द केस. सो हा एक प्रॉब्लेम झाला. आणि दुसरा झाला की ambulance, when it gets stuck up in the traffic, so at the earliest point of time it is not able to reach the hospital, आणि पेशंटचं ट्रीटमेंट लवकरात लवकर चालू होत नाही. सो हे दोन प्रॉब्लेम त्याने आपल्या इन्व्हेन्शन मध्ये सॉल्व्ह करण्याचा प्रयत्न केलाय. व्हॉट ही हॅज डन in the ambulance which is carrying the patient, there is a biometric scanner. So जो कोई injured person आहे त्याच्या बायोमेट्रिक स्कॅनरने स्कॅनिंग करून तो डेटा हॉस्पिटलला पाठवला जातो. इट इज लिंक्ड विथ द हॉस्पिटल. आय विल नॉट गो इन टू मच टेक्निकल डिटेल्स बिकॉज it won't be possible for you to understand those details. So the pre-medical history, it is such that the pre-medical history is made available to the doctor before the patient reaches hospital, so that proper line of treatment can be done on the patient. Secondly, traffic congestion madhe, as we have seen in the video, every ambulance is associated with a unique ID, and it is associated with a card which will be detected at the traffic signal controller at a specific distance, and that time the traffic signal will turn green, thus clearing the corridor or clearing the road for the ambulance. So we call it as a green corridor creation. Green corridor creation म्हणजे काय, तर सिग्नल ग्रीन होईल, त्यामुळे सगळे व्हेकल्स त्याच्या पुढचे जे ॲम्ब्युलन्सच्या पुढचे आहेत, दे विल कीप ऑन मूव्हिंग and the ambulance will not get stuck up, and the patient will be able to reach the yeah, I'm sharing the screen. I have not yet started my presentation. So patient will be able to reach the hospital at the earliest point of time. Just a minute. So this was something about this his invention. Now I'll share my screen. Okay. Yeah, is it seen now? Is it visible?
Yes, ma'am.
So to tell you about these two inventors or applicants, these are two engineer brother sister duo, म्हणजे तो आणि त्याची बहीण दोघांनी मिळून हे इन्व्हेन्शन केलं होतं. And these both are applicants to this invention. So कधी आमच्याकडे whenever the inventor approaches us, we have to tell them की which are the facilities offered by Indian Patent Office. So as sir rightly said, whenever there is a woman applicant, so you can proceed at a faster route of grant. You can proceed with the faster route of grant. So we advise him to, yes, your sister is also involved in the invention. So let us have her as a woman applicant and you as another applicant. So it will go on a faster route of grant. So now his patent in India is granted, and now As I said, he has established a private limited company. He got patent granted in India, and now he has applied for international patent. International patent म्हणजे काय तर patent whenever it gets granted in India, it is only the rights are only limited to India. म्हणजे काय, somebody said की territorial rights आहेत. Territorial rights म्हणजे whenever you file a patent in India, your rights will be monopoly rights or so exclusivity rights will be limited only in India. So if you want की माझ्या इन्व्हेन्शनला US मध्ये UK मध्ये पण स्कोप आहे, आय वॉन्ट मोनोपोली राईट्स. मोनोपोली राईट्स म्हणजे काय तर whenever you take a patent for a particular invention, you have those exclusivity rights to use that invention. म्हणजे काय तर ते प्रॉडक्ट किंवा प्रोसेस प्रोड्यूस करण्याचं, कमर्शियलाइज करण्याचं तुम्हीच फक्त करू शकता. दुसरं कोणीही ते प्रोडक्ट प्रोसेस वापरू शकत नाही तुमच्या परवानगीशिवाय. So that is called as a monopoly right. And whenever you file a patent, you get this monopoly right for 20 years. So पल्लवीने मगाशी एक स्लाइड दाखवली त्याच्यामध्ये काय होतं की डिस्क्लोजर ऑफ द पेटंट. सो व्हॉट यू डू वेनेवर यू फाईल अ पेटंट म्हणजे काय करता तुम्ही, तर तुम्ही पेटंट ऑफिसला तुमचं इन्व्हेन्शन कम्प्लिटली डिस्क्लोज करता, म्हणजे सांगता की हे माझं इन्व्हेन्शन आहे. अँड देन इन टर्न पेटंट ऑफिस ऑफर्स यू एक्सक्लुझिव्हिटी राईट्स फॉर 20 years. सो तसेच हे एक्सक्लुझिव्हिटी राईट्स ह्या मुलाला मिळालेत आता 20 वर्षासाठी. आता ही इज थिंकिंग की माझ्या इन्व्हेन्शनला बाहेर, मला इंडियाच्या बाहेर पण घेऊन जायचंय. देन ही हॅज गॉन फॉर अ इंटरनॅशनल पेटंट ऍप्लिकेशन. आता काय होतंय की पेटंट घेतलं म्हणजे काय, ते नुसतं त्याच्यावर घेऊन त्याचा काही फायदा नाही ना. ते घेण्यासाठी आपण खर्च करतो, आपल्या पेटंट एजंटला फी देतो किंवा काय. तर त्याच्या पुढे जाऊन पण त्या पेटंट घेतलंय त्या एक्सक्लुझिव्हिटी राईटचा किंवा मोनोपोली राईट्सचा जे आपल्याला 20 वर्षासाठी मिळालेत त्याचा फायदा करून घेता आला पाहिजे. म्हणजे काय तर यू शुड बी एबल टू कमर्शियलाइज दॅट पेटंटेड इन्व्हेन्शन. सो कमर्शियलाइज म्हणजे काय, सो इंडिव्हिज्युअल बीइंग अन इंडिव्हिज्युअल इन्व्हेंटर ही इज नॉट हॅव्हिंग दॅट कपॅसिटी की मी आता माझं मोठं प्रोडक्शन युनिट उभारेन, भरपूर सगळ्या लोकांना कामाला ठेवेन. सो ही इज नॉट हॅव्हिंग दॅट फायनान्शियल कपॅसिटी. आणि कॉलेज स्टुडंट्सची नसते पण. सो देर आर डिफरंट फोरम्स which help you raise funds for commercializing your patented invention. So he is approaching right now, he is at this stage approaching different forums for commercializing and funding purposes, and we are guiding him in this journey. So ह्या लोकल न्यूजपेपर मध्ये तो नागपूरचा इन्व्हेंटर आहे. सो नागपूरच्या लोकल न्यूजपेपर मध्ये त्यांनी असं त्याच्याबद्दल त्याचं हे कौतुकास्पद काम, ही सक्सेस स्टोरी पब्लिश केली होती. These are some photos which so this is the prototype of the invention. Prototype म्हणजे काय तर छोटंसं एक वर्केबल मॉडेल ऑफ युअर इन्व्हेन्शन you should have. Whenever you will file a patent, at least you should have a prototype, workable prototype. मग त्याचं कमर्शियलायझेशन तुम्ही नंतर करता, बट देन किंवा लार्ज स्केलवर मॅन्युफॅक्चरिंग नंतर करता, बट यू शुड हॅव प्रोटोटाईप ऑफ युअर वर्केबल प्रोटोटाईप. वर्केबल हा शब्द हायलाइट करायचा. कारण काय की इफ इट इज नॉट वर्किंग देन you may not be able to file a patent, or you may not be able to get it in the further prosecution if the examiner comes to know it is not working. So ते तुम्हाला नाही मिळणार. सो आता आम्ही जेव्हा पेटंट प्रॉसिक्युशनच्या वेगळ्या वेगळ्या स्टेजेस असतात. शेवटची स्टेज असते हिअरिंग. हिअरिंग म्हणजे काय तर पेटंट ऑफिसचे एक्झामिनर असतात, म्हणजे पेटंट ऑफिस मधले सिनियर ऑफिशियल्स आपण म्हणू असं. आणि ते आपल्याला व्हिडिओ कॉन्फरन्सिंगने, जसं आता आपण झूम मध्ये एकमेकांना बघतोय तसं व्हिडिओ कॉन्फरन्सिंगने ते इन्व्हेंटर, पेटंट एजंट यांच्याशी बोलतात. त्यांना काही क्वेरी असतील तर त्या विचारतात आणि मग आपण त्यांना सांगायचं असतं की अरे हा माझं इन्व्हेन्शन असं असं आहे. सो नागपूरवरनं पुण्याला तो हा प्रोटोटाईप घेऊन आला होता. आम्ही त्याचं हिअरिंग केलं अँड देन हिज पेटंट गॉट ग्रँटेड. हे सुद्धा काही लोकसत्तामध्ये पब्लिश झालंय हे 9 जानेवारीच्या. आता मला अजून एक गोष्ट दाखवायची. अजून एक आमच्या इन्व्हेंटर आहेत. सो शी इज मिसेस ललिता बोरा, आर्ट्स ग्रॅज्युएट आहेत त्या. बट हे का सांगते मी कशासाठी, कारण क्रिएटिव्हिटी हॅज नो रिस्ट्रिक्शन ऑन एज्युकेशनल क्वालिफिकेशन, ऑन एज किंवा काहीही. म्हणजे तुमची बॅकग्राऊंड, फायनान्शियल बॅकग्राऊंड, ह्या क्रिएटिव्हिटी किंवा सृजनशीलता जी आहे ती या सगळ्यांची लिमिटेड नाही आहे. तुम्ही क्रिएटिव्ह कधीही असू शकता. कारण तुम्हाला जे डे टू डे लाईफ मध्ये जसं मी म्हटलं की प्रॉब्लेम्स फेस करतो आपण. सो नॉट ओनली प्रॉब्लेम्स, एखाद्याला छान फोटो काढता येतात, एखाद्याला छान पेंटिंग करता येतं, एखाद्याला छान स्कल्पचर्स करता येतात, मूर्ती छान बनवणारे असतात, मूर्तिकार असतात, एखाद्याच्या हातात कला असते. जसं आपण आपल्याकडे येवल्याची पैठणी आहे. सो ही क्रिएटिव्हिटी जी आहे ती कोणत्याही वयाशी किंवा जेंडरशी किंवा फायनान्शियल बॅकग्राऊंडशी, कशाशीच, एज्युकेशनल बॅकग्राऊंडशी कशाशीही संबंधित नाही. तुमच्यापैकी सगळेजण तुम्ही क्रिएटिव्ह आहात आणि तुम्ही प्रत्येक जण काही ना काहीतरी इंटेलेक्च्युअल प्रॉपर्टी क्रिएट करूच शकता. सो शी इज वन ऍप्लिकंट. त्यांनी काय केली, हा अतिशय ट्विटरवरती अतिशय ऍक्टिव्ह असणाऱ्या, सोशल मीडियावरती ऍक्टिव्ह असणाऱ्या या इन्व्हेंटर आहेत. आणि शी केम टू नो की tobacco addiction is a biggest problem in India. Nearly 70% of death is happening because of this oral cancer किंवा ज्या तंबाखूच्या रिलेटेड जे काही प्रोडक्ट्स आहेत त्यांच्यामुळे ह्या जे काही प्रकारचे वेगवेगळ्या प्रकारचे कॅन्सर होतात त्याच्यामुळे 70% ऑफ द डेथ्स आर हॅपनिंग. सो त्यांनी विचार केला, ह्या आता या फूड टेक्नॉलॉजीमध्ये गेली 25 वर्ष काम करतात. त्यांनी हे पुस्तक सुद्धा लिहिलंय, एक फळ भाजीपाला प्रक्रिया उद्योग तंत्रज्ञान आणि उद्योग विषयक संपूर्ण मार्गदर्शन. हुएवर वॉन्ट्स की हा फूड टेक्नॉलॉजी मध्ये मला हा प्रॉब्लेम येतोय, से जांभळाचं काही जॅम बनवलाय आणि इट इज नॉट हॅव्हिंग स्टेबिलिटी, म्हणजे काय तर शेल्फ लाईफ त्याला नाही येते, काही 7-8 दिवसांनी त्याला बुरशी येते, या अशा प्रकारचे काही कोणताही प्रॉब्लेम, विच एनी प्रॉब्लेम यू टेक टू हर अँड शी विल सॉल्व्ह द प्रॉब्लेम, अशा प्रकारचे ह्या इन्व्हेंटर आहेत. सो त्यांनी हे तंबाखूच्या व्यसनाचा प्रॉब्लेम आयडेंटिफाय केला अँड शी स्टार्टेड वर्किंग ऑन इट. आणि माइंड यू की त्यांनी एक असं प्रोडक्ट बनवलं विच इज एक्झॅक्टली मॅचिंग विथ दिस तंबाखूचा जो जर्दा येतो त्याच्याशी एक्झॅक्टली लुक वाईज पण आणि टेस्ट वाईज पण मॅच होणारं असं एक प्रोडक्ट बनवलं. अँड देन शी applied, she wanted to, somebody told her about patent and then she filed for a patent, but unfortunately त्यांना कोणी प्रॉपर गायडन्स त्यावेळेला मिळाला नाही. सो शी केम टू अस ॲट लेटर स्टेज ऑफ प्रॉसिक्युशन. सो आता आपण जर बघितलं, ही प्रॉसिक्युशन आहे पेटंटचं. आधी तुम्ही पेटंट फाईल करता, मग पब्लिश होतं, ते 18 महिन्यांनी पब्लिश होतं. कशासाठी? लोकांना माहिती व्हायला पाहिजे की you have filed a patent on this particular topic. So for that patent office publishes it after 18 months. त्याच्यानंतर we have to request patent office. जसं तुम्ही एक्झामिनेशनच्या वेळेला फी भरता, एक्झाम फी, तसंच रिक्वेस्ट फॉर एक्झामिनेशन फी भरून त्यांना रिक्वेस्ट करायची असते की माझं पेटंट एक्झामिन करा म्हणून. सो सर एक्सप्लेन यू पेटंटेबिलिटी क्रायटेरिया की नॉवेल असलं पाहिजे, इन्व्हेंटिव्ह असलं पाहिजे, इंडस्ट्रियल ऍप्लिकेबिलिटी असली पाहिजे. सो हे पेटंटेबिलिटी म्हणजे काय, तर एक्झामिनर जो असतो पेटंट ऑफिसला बसलेला, तो काय करेल, तुमचं इन्व्हेन्शन वाचेल आधी पेटंट ऍप्लिकेशन, देन ही विल चेक की अरे खरोखर हे आहे का पेटंटेबल, ह्याच्यासारखं कोणी जगभरात कोणी पेटंट केलंय का, किंवा रिसर्च पेपर फाईल केला, पब्लिश केलाय का. सो इफ ही फाइंड्स की असं आहे, ही विल रिट्रीव्ह सम डॉक्युमेंट्स, देन ही विल लिस्ट देम आणि मग देन ही विल इश्यू अ फर्स्ट एक्झामिनेशन रिपोर्ट. सो रिक्वेस्ट फॉर एक्झामिनेशन हे कधी असतं, म्हणजे जसं मी मगाशी सांगितलं की वुमन ऍप्लिकंट कॅन गो फॉर फास्टर रूट ऑफ एक्झामिनेशन. सो दिस इन्व्हेंटर लेडी ललिता बोरा, शी वॉज नॉट टोल्ड, शी वॉज नॉट अनफॉर्च्युनेटली गायडेड की वुमन ऍप्लिकंट असल्यामुळे यू कॅन गो फॉर फास्टेस्ट रूट. So she met Pallavi in one of the forums and then they happened to discuss about her patent application. मग she said की अरे नाही, प्रोसिडच होत नाहीये फर्दर. मग त्या आमच्याकडे आल्या, आम्ही त्यांना सांगितल्यावरती त्यांनी तो दुसरा रिक्वेस्ट फॉर एक्झामिनेशनचा जो फॉर्म आहे, जो वुमन ऍप्लिकंट साठी आहे फास्टर रूट साठी, सो दॅट शी फाईल्ड थ्रू अस. देन फ्रॉम हिअर वी प्रोसिडेड टिल ग्रँट. आता ग्रँट झाल्यानंतर शी हॅज स्टार्टेड कमर्शियलायझिंग हर प्रोडक्ट. नाउ शी इज सेलिंग दॅट प्रोडक्ट ॲज अ समर्थ विडा. इट इज कॉल्ड एज समर्थ विडा because the basic ingredient used in this is betel leaves. Betel leaves म्हणजे आपली जी खायची विड्याची पानं असतात ती. सो ती वापरून त्यांनी जो काही तंबाखूचं हे बनवलंय तो त्यांनी त्याचं नाव समर्थ विडा असं ठेवलंय. त्यांनी ह्याच्यापासून सिगरेट पण बनवल्यात, गुटखा पण बनवलाय आणि किमाम पण बनवलाय. अशा डिफरंट फॉर्म्स मध्ये शी हॅज यूज दिस सेम फॉर्म्युलेशन और सेम कंपोजिशन. हे प्रोडक्ट आहे ते समर्थ विडा म्हणून, जे तंबाखूशी साधर्म्य साधतं. म्हणजे कसं तर टेस्ट वाईज किंवा लुक वाईज इट इज सिमिलर टू द टोबॅको और जर्दा वॉट एव्हर. आणि ह्या तुम्ही बघत असलात तर दीज आर सिगरेट्स. ओके, या सो हे होतं राष्ट्र सह्याद्री लोकल न्यूजपेपर मध्ये पब्लिश झालेलं त्यांचं आर्टिकल. सो ह्या 2 इन्व्हेंटर्सची मला स्टोरी सांगायची होती, ती मी माझ्या ह्याच्यातनं सांगितली प्रेझेंटेशन मधनं, की कसे आम्ही पेटंट एजंट म्हणून कोणत्या प्रकारचा रोल करतो. सो वी ऍक्ट ॲज अ ब्रिज, एक पूल बांधण्याचं काम करतो आम्ही. कोणामध्ये तर इंडियन पेटंट ऑफिस आणि इन्व्हेंटर किंवा ऍप्लिकंट. सो इन्व्हेंटर आणि ऍप्लिकंट असतात, त्यांना काहीच माहिती नसतं की पेटंट ऑफिसला काय पाहिजे, पेटंट अकॉर्डिंग टू पेटंट ऍक्ट हाऊ द पेटंट application should be drafted, how we should include, what are the different things we should include, what are the things we should not include. These all informations are not known to inventors and applicants in India because there is not much awareness about this intellectual property rights itself. So our job is to guide inventors or properly whatever facilities are available for them or offered by patent office to them. So to make them aware about these facilities is our job. So this is how we bridge the gap between patent office and inventor. So patent office on the other hand says की अरे ह्या ऍक्ट नुसार हे फॉर्म भरलेले नाही, पेटंट असं लिहिलेलं नाहीये, क्लेम्स असे लिहिलेले नाही. बट देन if the patent inventor reads this kind of claim comments from patent office, he will not understand anything. मेनी टाइम्स आमच्याकडे प्रॉसिक्युशन साठी इन्व्हेंटर घेऊन येतात ऍप्लिकेशन, पेटंट ऍप्लिकेशन. म्हणजे पेटंट फाईल केलेलं असतं, पब्लिश झालेलं असतं, मग एक्झामिनेशन रिपोर्ट येतो. एक्झामिनेशन रिपोर्ट मध्ये अंडर दिस सेक्शन you have to comply with these requirements. So what is this section is telling? Patent Act चा section म्हणजे काय? So this being an inventor, he will not be aware of these legal terms किंवा ऍक्ट. तर ते काम कोणाचं आहे तर ते आमचं आहे. का? कारण पेटंट एजंट जेव्हा आम्ही होतो, पेटंट एजंट इज अनदर अपॉर्च्युनिटी, करिअर अपॉर्च्युनिटी. पेटंट एजंट काय करतं तर पेटंट ऍक्टचा पूर्ण अभ्यास करतो आणि पेटंट एजंट एक्झामिनेशन देतो. सो बिईंग अ टेक्निकल पर्सन, ही इज अवेअर ऑफ टेक्नॉलॉजी ऑल्सो आणि लिगल पेटंट ऍक्टचा अभ्यास केलेला असल्यामुळे ही इज अवेअर ऑफ लिगल आस्पेक्ट्स ऑल्सो. सो ही इज अ टेक्नो लिगल पर्सन. सो पेटंट एजंट असल्यामुळे आम्हाला ती एक व्हॉट वी कॅन से की आम्हाला संधी मिळते की वेगवेगळ्या इन्व्हेंटर्सशी इंटरॅक्ट करून त्यांचे पेटंट ऍप्लिकेशन्स फाईल करण्यासाठी त्यांना मदत करणं, ते ग्रँट पर्यंत नेणं आणि पुढे जाऊन त्यांना कमर्शियलायझेशन साठी हेल्प करणं. सो अपार्ट फ्रॉम दिस इंडिव्हिज्युअल इन्व्हेंटर्स, स्टार्टअप्स सुद्धा असतात ज्यांना वेगळ्या वेगळ्या फॅसिलिटीज असतात, त्यांना गाईड करण्याचं काम आम्ही करतो. आणि आता सध्या ह्याच्यामध्ये आम्ही 16 स्टार्टअप्सना गाईड केलं. सो तुम्हाला काय सांगायचंय मला, स्टार्टअप्स म्हणजे काय तर आता इथून पुढे जेव्हा you will pass out from this, you will do your graduation, post graduation. So rather than being a job pursuant, be a job creator. So entrepreneurship चा हे करा, अभ्यास करा, त्याच्यामध्ये ट्राय बीइंग एंटरप्रेन्युअर. किंवा कारण आत्ताचे जे न्यू नॉर्मल आहे त्याच्यामध्ये नवीन नवीन संधी व्यवसायाच्या उपलब्ध होत आहेत आणि लोक त्याचा फायदा घेत आहेत. तर तुम्ही सुद्धा जॉब क्रिएटर्स व्हा, दुसऱ्यांसाठी रोजगाराच्या संधी निर्माण करा, रादर दॅन तुम्ही कोणाचा तरी जॉब करण्यापेक्षा, 9 to 5 जॉब करण्यापेक्षा तुमच्या क्रिएटिव्हिटीला वाव द्या आणि नवीन नवीन इंटेलेक्च्युअल प्रॉपर्टी निर्माण करा. तुमच्या कॉलेजकडनं होऊ देत आणि भरपूर पेटंट फाईल होऊ देत. ह्या सदिच्छेसह मी माझं प्रेझेंटेशन थांबवते. थँक्यू सो मच. आणि इफ एनीवन इज हॅव्हिंग क्वेश्चन्स, आय एम ओपन टू आन्सर देम.
Okay, ma'am.
Ma'am, I'm Dr. Mui from Chemistry Department.
Yes, sir.
2-3 questions from my side.
Yeah.
One of our 11th standard student, he invented a technique to construct angles, geometry angles.
Okay.
He approached me and asked me about filing patent. When I go for priority check, I found that according to Patent Act 1970, Chapter 2, Section 3, these mathematical constructions are not patentable.
Correct. Correct.
So what should we do in such cases? Whether we should go for copyright or research paper, or what we should do according to you?
Yeah. So he developed a method for what you said?
Construction of angles.
Construction of angles. Okay. So yes, you can. In this particular thing will go under the subject. This will be a subject matter for copywriting. So
Okay.
as you rightly said, Section 3 of Patent Act will not allow you to patent the mathematical methods. But I would like Dr. Dhumane to guide us in this this perspective, because he's the most expert person in this. So, sir, तुम्ही सांगा.
Since you are correct, Shalaka, because definitely there will no patent for this first.
Yeah.
And copyright is always there. You should publish as a research paper and get a credit for that. At least. You can.
Okay.
Suppose you can develop some instrument over there.
Okay.
So theoretical or paper work or formulation. You can some educational equipment. This angle, that phenomena to like many tools are available nowadays, education tool. That you may try for it, but not a mental game. It's not only for mental game. It should be some useful instrument to think about new educational tools.
The instruments you can go for filing.
You can get a patent.
Achha. And talking about IP literacy, we are going to start Kapila program in this month in our institute. That is Kalam program for IP literacy and awareness. The Ministry of Education's Innovation Council has started this program to fund the innovators to file the patent. So we are going to start in this month. Up to February 15th, we will complete with all that task. And last one, can you share the contact numbers of that Lalita Bora and that engineer guy who invented the ambulance technique, so that we can arrange motivational lectures of them to our students?
Sure, we will share.
Okay. Thank you.
I would just, can I add something to you? What you just said?
Yeah, sure, sir. Go ahead.
Because you said you are going to host a inventor Mela or something to fund the inventors, right?
No. We are starting a new program that is called Kapila. Ministry of Education's Innovations Council has started this program
to fund the inventors.
Yeah, to fund for filing the patents or to creating IPRs.
So you have to identify the invention which has been made by inventor. Many times what happens, the invention is not complete or not based on the prior art search. So funding that invention, you be sure that prior art search has been conducted and inventive step and novelty has been established to the reasonable extent. I'm not talking fully, because you cannot conduct full search, never. But reasonable search should be conducted to establish at least these three criteria.
Okay.
So
Inventor approaches us.
Profiling.
As the sir rightly said, whenever the inventors approach us with their invention, so we carry out first patentability search.
Yes.
Prior art search.
Prior art search. Reasonably means not in detail, but somewhat. So काय होईल की ते सगळं ते प्रायर आर्ट मध्ये चाललं जाईल काहीच मिळणार नाही म्हणजे फंड बेकार.
नाही एक असा आहे सर, यांचा प्रोग्राम जो आहे कपिला प्रोग्राम, त्याच्यात ते काय करतायत, तर तुम्ही पेटंट फाईल केल्यानंतर तुमची जी एक्झामिनेशन फी किंवा इतर जी काय फी आहे ते स्क्रुटिनाइज करून ती फी तुम्हाला देता येते. असा तो प्रोग्राम आहे. ओके, थँक्यू सर. डोले सर.
Okay, thank you, Dhumane sir. Thank you, Shalaka ma'am. Very nice presentation. I request to Dr. Dole sir for vote of thanks of Shalaka ma'am.
Thank you, Thorat sir. It is a great privilege to propose vote of thanks to all the dignitaries and participants who are virtually present here. First of all, I would like to thank our respected principal, Dr.W.M. Rajmane Saheb, for his presidential remark, for his motivational words, and respected Professor S.A. Patil sir, Professor N.R. Suryanshi sir, Professor M.B. Kamble madam, Professor B.J. Nalavade sir, Vice Principals of S.G.M College Karad, for supporting us, for inspiring us. I would like to thank Dr. G.B. Kalyanshetti, sir, IQAC Coordinator, Mr. Mahesh Gaikwad, sir, Librarian of our college, Professor U.B. More, who is virtually present here, RUSA Coordinator of our college, Professor Dr. J.B.Thorat, sir, HOD, Department of Physics, Dr. S.H. Pisa, Madam, Coordinator of this workshop, Dr. A.G. Mulik, President of CIII, and in the last, all the resource persons, Dr. Dhumane, sir, who delivered his lecture on strengthening IPR and innovation. Then Pallavi Kadam, Madam, who delivered his lecture on types of IPR, how patent is filed, regarding Indian patent website, copyright website, then how revenue can be generated from patent, then IPR regulations and practice methods. Then in the last session, Shalaka Tole Madam delivered her lecture on unique identification of ambulance, invention about flying EV, then why workable prototype is important to file a patent, and information regarding the Samarth Vida, that is nicotine-free tobacco. So thanks goes to our entire faculty who also stand beside us and guide us. Last but not least, on behalf of organizing committee, I thank all the participants from our college and different college for showing their meaningful presence. Once again, thank you very much to all. And with the permission of the president, head of the department and coordinator of this workshop, I declare that this workshop is concluded here. Thank you. Thank you very much.
Thank you so much.
Thank you. Thank you.
Limiting for all.